Okay, so thanks to Daisy B, we have Michael Gaffey, Judge Michael Gaffey's response to the motion to set aside the verdict. This isn't including the motion for the evidence to remain sealed. It's short, it's 4 pages. We're going to read the whole thing, and I'm going to tie it into with what we remember from the motion to set aside the verdict, which was quite a bit longer, 47 pages. So that's something. And while I'm not going to go punch for punch, detail for detail here, if you want to revisit either the motion to set aside the verdict, or if you want to look at that motion to, keep the Molyneux evidence sealed, you can go check out those videos. I'll link to them in the description. And more importantly, I did a long video on the justification charge and all of the case law. We took a deep dive into the case law in New York State that says, hey, the court erred or errs in situations where they fail to read a justification charge when the evidence is read most favorable to the defendant. If you want to take a deep dive into that, it's something that Judge Gaffey kind of dances over and says, hey, if you want to make an issue out of that, take it to the appeals court. We're not going to dive too deep into that issue in this short video, but I'll link to that video. It's great case law if you're a case law nerd like I am, to go watch, read that, check it out. But this motion here, and if you didn't already hear the news, and if you expected otherwise, it was denied. I don't think many people expected there was even a strong chance that a judge, the trial court judge, was going to say, oh, you're asking me to set aside these charges because I made an error, the court made an error. It's not very likely that that was going to happen anyway, but here we get to at least look at his reasoning why. So let's read it. By motion filed February 5th, 2024, defendant moves pursuant to Criminal Procedure Law 33030 to set aside the verdict rendered on December 18th, 2023, convicting him of assault in the 3rd degree and harassment in the 2nd degree. The people filed a response in opposition on March 5th, 2024. Defendant's reply was filed on March 12th, 2024. Upon review of the motion papers and exhibits, defendant's motion is denied. Now, let me pause there to say that we didn't see the response that the people filed on March 5th, and we also didn't see the defendant's reply. I'll try to take a look for those, and before I publish this video, either we'll jump into that at the end of this, or we'll do another video. We'll see if they're out there, but they might not be available. Brief procedural history. By prosecutor's information, defendant was charged with 3 counts of assault in the 3rd degree under an intentional theory, 3 counts of assault in the 3rd degree under a reckless theory, 1 count of aggravated harassment in the 2nd degree, and 1 count of harassment in the 2nd degree. The allegations stemmed from a March 25, 2023 incident between defendant and his girlfriend, Grace Jabari, his then-girlfriend. Defendant's jury trial commenced on November 29, 2023. Before the start of testimony, the people moved to dismiss 2 counts of assault in the 3rd degree under an intentional theory and 2 counts of assault in the 3rd degree under a reckless theory. There was no dispute at trial that the 2 remaining counts of assault in the 3rd degree and 1 count of aggravated harassment in the 2nd degree related to events that occurred inside a hired vehicle, while the count of harassment in the 2nd degree related to events that occurred outside the vehicle. On December 18, 2023, the jury convicted defendant of reckless assault in the 3rd degree and harassment in the 2nd degree, and acquitted him of the intentional assault and aggravated harassment counts. The court adjourned the case to February 6 for sentencing. On February 5th, defendant filed the instant motion to set aside the verdict. Accordingly, at the February 6 court appearance, the court set a schedule for the people's response and the defendant's reply, and adjourned the case to April 8, 2024 for sentencing, with a decision to be rendered off calendar. That was April 1st, and this is the decision we're reading now. And now we get to the discussion, which gives us some insight into Judge Gaffey's decision-making process here. At any time after a verdict of guilty and before sentencing, a defendant may move to set aside or modify the verdict if there is, quote, any ground, and this italics is emphasis, appearing in the record, which, if raised upon an appeal from a prospective judgment of conviction, would require a reversal or modification of the judgment as a matter of law by an appellate court. A trial judge's authority to set aside a verdict on these grounds is, quote, normally limited to a determination that the trial evidence was not legally sufficient to establish the defendant's guilt of an offense of which he was convicted. Now, if you've gotten to watch any of the live streams with Danny and Kirby on this subject, Kirby said it over and over, legal sufficiency of the evidence is really the argument that someone would want to make at this stage, even though you could try to make others, the appeals where you're really going to come with the kitchen sink. But sufficiency of the evidence was something that Kirby kept saying. That could be a good one. That could be a good one. I'll link to those in the description as well if you want to check out those streams. The legally sufficient evidence is, quote, competent evidence which, if accepted as true, so it's just an if, it just has to be an if, would establish every element of an offense charged and the defendant's commission thereof. The court must view the evidence in the light most favorable to the prosecution. Defendant first argues that his conviction of reckless assault in the third degree should be set aside because the court erred in submitting the count to the jury. This court disagrees. At the outset, contrary to defendant's contentions, the court submitted the count of reckless assault as an alternate theory to the intentional assault count, and not as a lesser included offense. We have a footnote here that says, the verdict sheet also properly indicated to the jury that they were to consider the assault counts in the alternative, and cannot find defendant guilty of both. And here, the evidence at trial, quote, did not compel the conclusion that defendant committed an intentional assault or no assault at all. Rather, there was a reasonable view of the evidence to support that defendant acted recklessly. During the people's case in chief, Ms. Jabari testified that after she grabbed defendant's phone, defendant tried to, quote, pry the phone out of her fingers, and that he was, quote, really trying to let her let go of the object she was holding, peeling it away as much as he could. So what Gaffey's saying here is, hey, in your motion to set aside the verdict, when you addressed this issue, the defense said, hey, it doesn't make sense that the jury could convict him on recklessness when the only evidence on the record all goes to intent. The words trying suggests intentional. But here Gaffey is making these quotes where the word trying is still included, but seems to be, well, it's not that he was trying to hurt her, but he was trying, the intent there was to try to get the phone. The recipient of the intent was the phone. Therefore, anything that could have occurred that the jury could have inferred occurred to Grace Jabari during this time could have been reckless, because his intent was only directed at the phone. I think that's a stretch of an argument personally, but I understand that a trial judge isn't going to weigh this in the effort of justice. That's something that an appellate court would do. Secondly, this line of argument right here kind of goes to you should have read the justification charge, sua sponte, because she had the phone and he was just trying to get it back. Those are just my thoughts and analysis on this part so far, but let's keep going. He also yanked Ms. Jabari's arm and twisted her arm and her hand behind her back. Shortly thereafter, Ms. Jabari testified that, in the continuing struggle for the phone, defendant struck the right side of her head, at which point he was able to retrieve the phone from her hands. Ms. Jabari testified that she suffered a broken finger and a lacerated ear as a result of the defendant's actions in the back of the vehicle. Thus, the jury reasonably could have concluded that defendant recklessly caused physical injury to Ms. Jabari during this rapidly unfolding struggle over the phone. Now, they're using this word in quotes here, this phrase, rapidly unfolding, because in this case law that he's citing, People v. Dodson, this is part of the argument. In the context of this rapidly unfolding barroom incident, in an emotionally charged setting, the jury reasonably could have found that the defendant did not intend to cause injury to the complainant and instead acted recklessly. And I do want to look at this. Let's look at People v. Dodson. This is the 2005 case that we just looked at that was cited over as, case law, as precedent. The complainant, a talent scout, had gone with two friends to a Manhattan nightclub where musicians were being showcased. In the crowded basement lounge, someone bumped into her, causing her to spill her drink on Lisa Brown's coat. After the complainant apologized and tried to assist Brown in cleaning off the coat, the two got into an altercation. The complainant and her companions testified that Brown verbally abused all three. Eventually, defendant intervened and, according to one of the complainant's companions, asked Brown if he should cap the complainant. Defendant approached the complainant, looked her in the eye, and punched her. She swung back, and defendant then hit her in the mouth, knocking her to the floor. Defendant then kicked her at least twice in the lower back as she was trying to get up. Brown's version of the confrontation was that the complainant was the aggressor, that she herself then kicked the complainant, and that the defendant was merely a bystander. So basically, defendant comes up and just jumps in and punches someone. Defendant was arrested at the scene and charged with intentional and reckless assault in the third degree, so both. At trial, after defendant's unsuccessful motion to dismiss the count of reckless conduct, the jury acquitted defendant on the intentional count, but found him guilty of reckless assault. So, what they found him reckless of was walking up, looking her in the eye, then punching her, then continuing, then hitting her in the mouth, then knocking to the floor, then continuing to kick them in the lower back as she was trying to get up, not currently still fighting them. When something is used as precedent, as case law, it needs to be situationally similar. Gaffey is making the argument here that this is situationally similar and that it was fine that a reckless and intentional charge were presented to the jury. Because a rapidly unfolding struggle over the phone, because he's using these words, matched the situation, what was going on in the car, according to Grace Jabari's testimony, which we only have the driver's testimony for and Grace Jabari's testimony for inside the car. This other situation, he says, is parallel, and it's case law that he's using to make his decision that it was fine. That it was fine that both of these assault counts, reckless and intentional, were presented as a decision the jury could determine in the alternative of one another. He's saying this is a situational parallel. But what's the difference here? One, I would argue this behavior is a lot different than trying to get a piece of property back. There's also continued aggression. Not just a tussle, but an actual intentional look in the eye and just going, boonk. And then continuing to do so when the person's on the ground, not fighting back. Maybe she swung back once, but once she was on the ground, it doesn't say she was fighting back. Secondly, there are multiple witnesses here. There's multiple people here. Multiple people. So, continuing on with this specific appeal decision, which they maintained, they affirmed what happened at the trial court. They didn't reverse it. At trial, after defendant's unsuccessful motion to dismiss the count of reckless conduct, the jury acquitted defendant on the intentional count, but found him guilty of reckless assault for all of this that we just read, all of this stuff. That's what they found him guilty of for reckless assault. For the appeal, defendant now argues that the misdemeanor information was jurisdictionally deficient with regard to reckless assault, and, in any event, the evidence did not support such a charge. We disagree. The prosecutor's information charged defendant with striking the complainant about the face with a closed fist, causing her lip to swell, and repeatedly kicking her in the back, causing lacerations and substantial pain. Such an allegation should not be subjected to an overly restrictive or technical reading, so long as it fairly gives the accused sufficient notice to prepare a defense. Defendant argues that at best, the people made out a case only of intentional assault, which the jury rejected, and that the evidence was lacking with regard to reckless conduct. Quote, a person acts recklessly with respect to a result or to a circumstance described by a statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exists. The same conduct that amounts to recklessness may or may not also meet the definition of an intentional act. In People v. Cameron, the court rejected the defendant's argument that striking his victim in the face with a glass beer pitcher could only be viewed as intentional conduct and not reckless conduct. In the context of this rapidly unfolding barroom incident in an emotionally charged setting, the jury reasonably could have found that the defendant did not intend to cause injury to the complainant and instead acted recklessly. So I've already given my thoughts on the situational differences. Yes, there's a fight. Cool. But there's differences here. There's significant differences here. But secondly, we have this unjustifiable risk that's part of, finding the assault. And this is where we tie this into the issue. We're missing that element of, even if Jabari, her testimony, if we take it at face value, she still admits that she had taken his phone. We get into the issue of justification as a defense, one that does not need to be asserted in the affirmative. So, if you are watching this video and haven't seen my other videos on why didn't the defense just say, oh, yeah, he hit her, but he did it in defense. It was justified because she took his phone and started it. Well, they don't have to do that. There's plenty of case law. We've gone through those in the videos. Check out the links in the description for that. We're going to move on and keep looking at the judge's decision. So after Judge Gaffey lays out why he thinks People v. Dodson gives him the basis to deny this argument, he does have a footnote here that says, while defendant points to testimony by Ms. Jabari that she believed defendant was, quote, trying to hurt her during the struggle for the phone, she also testified later that her injuries were caused by the defendant trying to get the phone off of her. Either way, such testimony amounts to little more than speculation concerning defendant's state of mind. First of all, this is inconsistent. This is inconsistent testimony. Which one is it? Because I believe she's also suing him civilly for intentionally trying to hurt her. Anyway, I also think this footnote is kind of crazy here because, he's using this footnote as a counter to setting aside the reckless charge. But it also aids an argument that the justification charge should have been read sua sponte, because he's again creating this, hey, she testified that this happened because of the phone. And if this happened because of the phone, there should have been a justification charge read sua sponte, according to New York State case law. Now let's keep going. Defendant next contends that the court should not have submitted the reckless assault count to the jury without a justification charge. This argument is wholly unpreserved. So the problem with this defense is what Judge Gaffey is saying. There's a problem with you contending this issue because you didn't try to bring this up at trial. So, as a result, this court is without power to consider it. And he puts this case law here, People v. Taylor. But what I suspect is going on here, this 330-30 motion, this motion to set aside, this appeal said, when it comes to a motion to set aside a verdict, remember, a motion to set aside a verdict is a post-conviction but pre-sentencing remedy that the defense can bring to the trial court judge, who in this case is Judge Gaffey. But this case law says that when it comes to the motion to set aside a verdict, specifically, and not an appeals court, not an appeal judge, not a motion to appeal or anything beyond this, but specifically as it pertains to a motion to set aside the verdict, this type of motion, quote, must be based upon an on-the-record claim. And court was without power. So me, Judge Gaffey, the trial court judge, is without power to consider unpreserved repugnancy claim. This is not saying that that argument is moot on its face. It's saying that for this motion, for this type of motion specifically, since it's not on the record, I can't decide on that issue. Counsel neither requested such a charge during the charge conference nor objected at a sidebar after the court read its final charge to the jury. But also this part that I have highlighted, that counsel did not raise a justification defense at trial. They didn't have to. And the appeals court is supposed to look at the record in the light most favorable to the defendant on such an issue. If there's anything on the record at all that could have suggested justification, the defense doesn't have to have raised it at trial. The court should always sua sponte instruct the jury with a justification charge. So what's Gaffey saying here? This stuff all wasn't on the record. And it was strategic in a way for the defense not to put it on the record, because they offered alternative explanations for when the injuries could have occurred. They didn't want to get up there and say, yeah, these injuries happened in the car and Jonathan Majors did them. There were other opportunities, and the evidence suggests strongly that there were other ways and other mechanisms by which Grace Jabari got her injuries. So strategically, it makes sense that the defense didn't get up there and say, yep, he did it and he's justified, here's why, and he did not have to. They did not have to. But let's keep going. Counsel did not raise justification defense at trial and instead argued that Ms. Jabari sustained her injuries later in the night after she left defendant. Certainly on appeal, defendant is free, although they did try to get in evidence here that it was sustained in car part 2. So Judge Gaffey's missing a lot here. They did make this argument, but that wasn't the only argument they made. They said that could have happened because you weren't injured at this point in time yet, were you? Nobody noticed blood yet at this time, did they? But they did offer several points to suggest, hey, you're getting out of the car again. Did you not tell the officers that you struck him in the second part of the car? 10 minutes later? Anyway, certainly on appeal. So what is Judge Gaffey saying here? And this is not surprising at all for a trial court judge to pass the ball on to the appeals court. Certainly. Absolutely. Certainly. What does certainly mean, guys? On appeal. On appeal. Defendant is free to request that the appellate term exercise its interest of justice jurisdiction and reach whether the court should have sua sponte charged justification or alternatively. So he's saying certainly go request the appeal term. Because this motion, according to this case law, is not the type of motion where I, as a trial court judge, can consider this unless it's on the record. But the appeals court can, certainly. In fact, while they're considering that, go request that. But alternatively, consider asking them whether trial counsel was ineffective for failing to request such a charge. Now, this might seem snarky, right? Because ineffective counsel seems like a dig at the defense, and maybe it is. But I would suggest that it's only a snark comment in part, if at all. Because it's saying, hey, either you made an error here by not raising it to me on the record, to the court on the record, because now I can't consider it in this motion that you're filing now. If you requested it on the record, not only could I have fixed it then, but I could have considered it in response to this motion that you're filing to set aside the verdict. But because you failed to put it on the record, I can't help your client, even though there may be a very valid argument here for me to, with this post-conviction motion, to set aside the charge here, this one charge. So because I can't consider it because you didn't put it on the record, you could also make an ineffective counsel argument on appeal. And guys, if you haven't looked at appeals, this argument is something that trial counsel makes about themselves more than you would think. And it doesn't mean that it always works. But on appeal, try it. If the argument has merit, an appellate division could agree. But Gaffey's saying here, either way, I don't have the ability to consider this argument that's part of your 330-30 motion. I don't have the authority here as the trial court judge for this type of motion. It has to go to the appellate division. It has to go to the appeals court. Because one, it must be based on an on-the-record claim. And two, you didn't raise an issue of ineffective counsel in this motion, this 330-30 motion. But you can go do that on appeal. You can do either of these on appeal. Go ahead and do it there. And it's really not unusual for a trial court judge to pass the buck on. I think this is actually a very, very interesting paragraph, especially, we've criticized Gaffey throughout the trial, whatever, but he's actually citing case law where sentences were vacated for this issue, and he's saying go raise them. And if we take a quick look at this case law, so there was some modifications there. We're obviously dealing with different charges. There's multiple instances, multiple victims at gunpoint, at a daycare where infant children are present, so maybe not a situational parallel because one's taking place at a church, one's taking place at a daycare. There's a lot going on. 9 victims identified, the weapon that was recovered, a BB gun. And the defense counsel actually requested that the court submits a robbery charge in the second degree as a lesser included offense of robbery in the first degree. Now, this is a little bit different than what happened with the charges in the Jonathan Majors trial, especially who was requesting them. But they say here that defense counsel in this trial here that we're looking at did not request and indeed expressed a lack of understanding of the prosecutor's request for a jury charge on the affirmative defense to robbery in the first degree, that the BB gun displayed was not a loaded weapon capable of producing death or serious physical injury, which would have distinguished the offenses from each other. So, defense failed to not request this. The defense could have done this, and they didn't, and the court ended up reading almost identical charges to the jury on first and second degree robbery counts, and the jury convicted the defendant of 5 counts of robbery in the first degree and 2 attempted robbery in the first degree. And so we're modifying the sentence because even though defense didn't do this in the interest of justice properly, it should have been second degree and not first. So the appeals court is modifying from first to second as we read above. Now what's important here is they note, all right, we're talking about, not great representation here, and no trial strategy justified defense counsel's failure to request. With Jonathan Majors, we know there was trial strategy. There were other points in the night, the defense said, that your injuries didn't exist yet, and then all of a sudden they did. Is that not true? Or there's another time period, 10 minutes later in the second part of the car, where you say that you struck the defendant, Jonathan Majors, with the hand that you had injured. So, this is why we're not going to take an affirmative defense. And remember, the justification charge, guys, is not an affirmative defense. So that's separate. They didn't have to... The justification charge should have been read anyway. Go watch those videos to deep dive into that before I go off on a tangent here. But here we're also seeing, and let me zoom in a little bit, the appeals court says the trial court compounded the defense counsel's mistakes. So both, because Judge Gaffey here is kind of saying, in the alternate, say, hey, this justification charge should have been read sua sponte. but take it to the appeals court, or alternatively, ask them to look at ineffective assistance of counsel because you guys didn't do anything on the record, which would let me consider this mistake either at the time of trial or now in this 330-30 motion. This case law he cited, and I get why he did it, says, hey, the trial court compounded the defense counsel's mistakes. So defense counsel was a bit ineffective, and then the trial court did something to make it worse, because they erroneously charged the jury on robbery in the second degree as a lesser included offense of robbery in the first degree without instructing the jury regarding the affirmative defense to robbery in the first degree. So one big mess. The jury's confusion with regard to the almost identical charges became evident in its question to the court. If you paid attention to the deliberations week, we know that the jury came back several times with questions asking to clarify what the charges meant, which, according to this case law that Judge Gaffey cited, and he's telling the defense, go to the appeals court, because look at this. It says, well, the jury was clearly confused on the almost identical charges. That's evidenced by their question to the court. And then in this trial, just so you know, the state, because of this appeal, consent to forgo a new trial to correct this error and agree to a reduction of the convictions to robbery in the second degree and attempted robbery in the second. So I want to be clear, and I know at the beginning of this video I said I'm not going to touch too much on the case law, but if you want me to, let me know. No, I got curious and I wanted to look, and this paragraph is actually, Judge Gaffey tells us a lot in here, and on a first read you might be like, oh, he's ignoring things. No, he's actually pretty strongly suggesting, yes, I can't change this decision because of this type of motion. I'm limited because something's not on the record. But I'm going to certainly, you can go do this on appeal. Here's case law that shows exactly that. And in that case, they said there were a lot of errors. It was much more significant charges, different situation. But still, there was a whole mess about requests and how the jury was actually instructed. And the jury was clearly confused in People v. Fredericks, and we see the same parallel with jury confusion over here in the Jonathan Majors case. Let's keep reading. Finally, the trial evidence was legally sufficient to establish defendant's guilt of harassment in the second degree. A person is guilty of harassment in the second degree when, with intent to harass, annoy, or alarm another person. Now, remember, there has to be mens rea here. Intent to harass, annoy, or alarm. We are now talking about the harassment outside of the car. So we're focusing on what was in that video, and remember, I don't know if it was made in front of the jury, but this is where Michael Perez was saying that in that video, the intent is on his face. So, a person is guilty of harassment in the second degree when, with intent to harass, annoy, or alarm another person, he, quote, strikes, shoves, kicks, or otherwise subjects such other person to physical contact, or attempts or threatens to do the same. Here, Ms. Jabari testified that after she and defendant got out of the vehicle, defendant held her by her arms and tried to push her back into the vehicle. The people also introduced video evidence to corroborate her testimony. Such evidence clearly established that defendant subjected Ms. Jabari to physical contact. So he's saying that this part element here is met. Otherwise subjects such person to physical contact. He's not saying that it was clearly established that he's striking, shoving, or kicking. Such evidence clearly established that the defendant subjected Ms. Jabari to physical contact, and the jury reasonably could have inferred his intent from the conduct and surrounding circumstances. Now, if you notice, this is a very, very short paragraph to address this argument. This footnote was relating to something we read earlier, so really we just have a few lines here, and then 3 more lines here. And we're going to see that for these reasons, the defendant's motion to set aside the verdict is denied. Gaffey signs off on it. But I really want to talk about, because the defense made the argument that, hey, for this harassment charge, it was legally insufficient. There's not enough to establish the defendant's guilt of harassment in the second degree here. And the elements have to be not just this harass, annoy, or alarming by doing any of these actions here. There has to be mens rea. And I think this argument on mens rea is weak. We have down here Judge Gaffey saying, yeah, well, we have her testimony, whatever. But then the people also introduced video evidence. Such evidence clearly established, this video clearly established her testimony. So even though we only had her word, this video is really where we see clearly that there was physical contact. Just subjected to physical contact. clearly established this one element. This video clearly establishes physical contact. But then this rest of the sentence says, and the jury reasonably could have inferred his intent from the conduct and surrounding circumstances. So the other element required is not clearly established. Not clearly established. Just only could reasonably have been inferred from his intent. Now, your intent could be from conduct, from demeanor. And he's saying also the surrounding circumstances. But if we speak about surrounding circumstances, what do we have before this? What do we have before this? We don't have video inside the car. We have her testimony, which is contradicted by the driver. And we also have her own testimony, which is kind of inconsistent in and of itself. That's before. What do we have after? We have video evidence of right after this moment, where there's physical contact of some kind. And we're supposed to be able to infer intent from it. But what happens immediately after? What's the immediately surrounding circumstance here? He runs from her. I'm going to pull up a double feature of two of my favorite people, Chillmonger and AV to the 7th power.
Who's running after who?
A dropping surveillance tape where it appears Jabari is pursuing Majors after...
Okay, okay, hold on. Now I'm getting a little skeptical.
What are the surrounding circumstances?
He's running away. I thought he was running after her.
She's chasing him. She says, give me that phone back. I thought I was supposed to be your Michelle Obama.
So, clear evidence of physical contact. That's only one element. There has to be intent to harass, annoy, or alarm. Judge Gaffey's saying, well, the jury could have reasonably inferred his intent from the conduct and surrounding circumstances. Is that a reasonable inference? What was the conduct and surrounding circumstance? This is where I'd like you guys to weigh in. So I'm going to wrap it up there, guys. Again, I did a full deep dive into the justification charge, the case law saying in New York State that it should have been read and that it's not an affirmative, well, by code, it's not. By statute, it is not an affirmative defense. But there's case law saying that with this justification charge, it should be read even if an affirmative defense isn't asserted at trial, it's not on the record. And in deciding, the court needs to decide whether this justification charge should be read if there's anything on the record at all that suggests that there's some type of justification need. Someone taking personal property and someone's trying to get it back would be the example here. I did a full deep dive. You can see I went through all the cases cited in Priya's motion and more. So if you guys want to take a deep dive into all of that stuff, I'll link to that video in the description. That video has a link to all of these links that you're seeing on my screen right here. And again, I'll link to those other videos. I'll drop links to Danny, Chillmonger, AV to the 7th power. You guys can have a great time. But really let me know your thoughts on, reading this, decision from Michael Gaffey. Let me know your thoughts on this. And just as my final thoughts, my own analysis, I'll probably join the chat if I premiere this video to be chatting with you guys throughout. But, in case I don't do that or for whatever reason, my thoughts on this are, this was kind of expected anyway. You don't really see motions to set aside the verdict being granted by the trial court judge that presided over what, a lot of the arguments in the motion to set aside the verdict were criticisms of the trial court. And then you're asking the trial court, hey, you didn't do this right. But I actually really enjoyed this paragraph. I know you've heard me criticize, and I hope you didn't think I would come in here just swinging a bat at Gaffey just for the sake of it. I really did enjoy this paragraph here where he says, look, because it's my opinion that trial judges will pass the buck on to the next person to make the decision. It's not unusual. But here, Gaffey actually said, look, there's case law that I can't make the decision on this argument here. But there's case law that the appeals court found in favor of the same argument that you're trying to make to me. I'm just not the right person to make it. Go make that over there. Certainly you can go do that. So let me know your thoughts in general, but let me know your thoughts too on this specific paragraph and the way Judge Gaffey's approaching it. Do you think I'm just being too gracious here? Do you think I'm not being critical enough? Whatever you think is fine. But But I really think that this is some good food for thought, and I've criticized Judge Gaffey for certain things that he said on the record, the way he handled objections, things he chose to sustain. My favorite statement from him that I love to criticize is, oh, the witness is about to tell you what really happened, which gives the implication to a jury that what a witness, who the jury is tasked with deciding if they're credible or not, truthful or not. The judge is kind of saying, well, they're going to tell you what truthfully happened. There's an implication behind that type of wording, and I really hated that he said that. So I'm not afraid of criticizing Judge Gaffey, but I do think he deserves credit for this paragraph here. What do you think? All right, turning the floor over to you guys. Thanks for joining. If I'm in the premiere with you guys in a chat, thanks for joining me in advance. If you're watching this after it's premiered and you're just going to hop into the comments section, hello and hey to you. Thanks so much for stopping by. Check the description for more. Take care, you guys. Have a good